Welcome to Dolly Talk. How is everybody doing? We have a interesting trial today out of Tennessee. State v. Sherrick Vaughn. He is pro se, was apprehended. Hey, Mavka. Apprehended last year by the marshals. So he was a bad boy. Have not dug into his Facebook yet, although Scott found it. I think he's an aspiring rapper, which is nice. Eccentric. He's a interesting fella. But how you doing, Paul? Hope you're well. Let's see. Yes, Junior. Yeah. Okay, come here. One over. Erica, how are you doing? Thomas is here. Louise. Jim. So we will start. You good boy. Oh, thank you, Thomas. They're usually pretty well behaved for the most part. Yeah. Okay. So first, what we're going to do is check out this article from December 13th, 2024. The U.S. Marshals. Let's see. Wait a second. I have a second monitor to do this. U.S. Marshals captured a violent West Tennessee fugitive, Sherrick Vaughn, in Middle Tennessee. Did not know Tennessee had violent fugitives, but there you go. The Hardin County Sheriff's Office investigated an incident that resulted in warrants issued for the arrest of Sherrick Vaughn for 3 counts of aggravated child abuse. Oof. So the Two Rivers Task Force developed info that Vaughn was in Middle Tennessee and provided investigative leads to the USMS Middle Tennessee Joint Fugitive Task Force. He was arrested without incident and transported to the Humphreys County Jail. In addition to the Hardin County charges, Vaughn was wanted in Decatur County, Tennessee for possession of a weapon by a convicted felon. Damn it. He is also wanted in Dickson County, Tennessee for aggravated assault, reckless endangerment, possession of a weapon by a convicted felon, and false imprisonment. So he is a eccentric little fella who's been quite busy. Today, I believe the charges are just intimidation of a police officer, because our boy is he's a little afraid of women, as we'll come to find out. He doesn't like women to touch him. He's had issues with women, I think. So we'll find out about that. We have a very young officer who he threatens, and hilarity and hijinks ensue. So we will start now. This trial just started today. I was hoping. Oh yes, retaliation. Thank you, Thomas. I tried looking it up this morning, but I couldn't find anything current on him on the Tennessee website. But yeah, it was retaliation. So there was a pretrial hearing. I'm not going to cover that right now. Maybe if there's like a verdict watch or something, we can do that. But we'll get started with opening here in just a second. So this started from 3 hours ago.
But before Corporal Stewart's testimony, we may have a short jury out on an issue, his testimony. But that, I think, should be the only thing that's taken up.
All right. Then you have some issue, there's nothing been filed in, to my knowledge, that would affect that, but we'll take that up whenever it gets to it.
And, well, I can address the reason it hasn't been filed now or later.
You what?
The reason that it hasn't been filed
Go ahead.
is because I think it just probably came to light at the motion hearing. Necessariness for it. Necessary as to the necessity of it. I'm sorry.
All right, well, the jury's been sworn, we're proceeding with the trial. He's pled guilty to count 1. We will move to count 2, which is count 2, because we've obliterated the original count 2, and now count 3 is count 2. So let's go ahead and put on our proof regarding that. And when you get to a witness that you need a jury out hearing, you will need to allow me to let me know, and then Mr. Vaughn can argue as whatever it is he wants to argue. All right, bring out the jury, please.
Bring the jury. And he's got, sounds like another trial coming up after this. Not sure if it's the same county or not. Or no, I think it is actually, yeah. They just didn't do all the charges at once. Hey, Maddie.
You are going to get a snapshot of the incidents that happened on June the 22nd of 2022.
Wonder how he feels about having a prosecutee go after him.
The defendant having already pled to driving on revoked, the state will be presenting proof in our case in chief only on the charge of retaliation for past action. Now, what you will hear in the proof is that on that night, Officer Javvens had a reason to stop and talk to Mr. Vaughn, and that Mr. Vaughn, the defendant, was arrested. You will be able to see the video of when he arrives at the jail and begins to make comments to Officer Javvens. Okay. You will be able to hear his exact words. It will be up to you to decide exactly what those words are. Some of the ones that will be fairly clear will be, I am a threat for a reason. Okay. When Officer Javvens finishes up her paperwork, she needs to retrieve her handcuffs. When an officer arrests a person, those are that officer's handcuffs. And when that person is in the custody of the jail, it's normal that they switch out the handcuffs and put jail cuffs on, and the officer takes their cuffs with them should they need to make any other arrest. It is at that point that Mr. Vaughn is going to begin to become agitated, to become upset. He will state that he does not want this officer, a female, touching him. Mm-hmm. He will say that if they take the cuffs
Boy, and he doesn't even object to that. Ouch.
off, he's going to break her jaw.
She has cooties.
He will make several comments that you will get to hear while Officer Javvens is there. And then later on, you will hear from another officer that will talk about comments later on. And all of those comments taken together will be the state's proof for retaliation for past action, which is the making of a threat against an officer for actions taken in the course of that officer's duty.
Mr. Vaughn, you may address the jury if you choose, or you may waive your argument.
Yoo-hoo. Something you'd like to share with the rest of us? Secrets are no fun.
Mr. Vaughn, do you wish to address the jury?
1 second, Your Honor.
This is going great.
If
Take your
Mr. Vaughn is
time.
going to address the jury, he must do so now.
Your Honor, I wish to waive open statement and reserve for defendant's case in chief.
All right, defendant has waived his right to make an opening statement, so General, you may start your
Okay.
proof.
State calls Corporal Lindsay Javvens.
Hey.
Confirm the testimony given in this case be the truth, the whole truth, nothing but the truth.
No worries, Louise.
Are you Corporal Lindsay Javvens?
Yes, ma'am.
Now, some people say Javvens instead of Javvens. Is that right?
Yes, ma'am.
We are ringing a little bit.
Yeah, I think it's me.
Would you spell your first and your last name for our court reporter?
Lindsey. My last name is Javins.
And how are you employed?
Oh, the City of Dickson Police Department.
And were you working for the city in June of 2022?
Yes, ma'am.
How long have you been in law enforcement?
Since 2017.
And is Dickson Police Department the only law enforcement agency that you've worked for?
No, ma'am. I previously worked for Fairview Police Department.
And on June the 18th of 2022, did you come into contact with the defendant?
Yes, ma'am.
And as part of that conduct, did you end up placing him under arrest?
Yes, ma'am.
We are going to focus on the event once he is taken to jail. So are you and he the only ones in your patrol car?
Yes, ma'am.
Were there other officers on scene earlier?
Yes, ma'am.
So once you arrive at the jail, explain to the jury sort of the sally port and how it goes to take someone into the jail.
Yes, ma'am. So whenever you pull into the jail, you drive around the side. There's a front gate. You press a button, tell them what you're there for. They let you in the front gate. And then you go to another gate, and that gate opens. And then you go into a sally port, which is essentially like a kind of like a pull-through garage. And it's a secure area to bring whoever into the jail. So we were in that sally port area. That's essentially like a garage. There's a door right beside where you would park your car to enter into the jail booking area.
On the ride to the jail, was the defendant, describe his demeanor.
On the way to the jail, like when we first started driving to the jail, we had been joking around and talking. We had just had a pretty reasonable conversation at the police department. We were on good terms at that point in time.
That's
Is
cute.
that unusual when you're transporting someone?
Not usually. I mean, after a point in time, sometimes people will, start having conversation with you. Sometimes people are mad the whole time. It fluctuates.
And did he remain calm or did he become agitated at some point?
He remained calm until we got to the sally port.
What is the first thing that you would pinpoint as him getting agitated?
Whenever he said that my name's not Lindsay, when he was getting out of the car, and then he said that I lied to him like all women do.
And how did it go from there?
Like all women do.
So
Like my
he
goddamn
is stepping out of
ex-wife.
the car. As he's getting out of the car, he said, "Your name's not Lindsay." And I said, "Yeah, it is Lindsay. My last name is Javvens," because our name is on our uniform, and he saw the Javvens. I said, "I just typically do first name basis with people because it's easier to remember than Javvens. Javvens is kind of hard to remember." So he started getting upset about that. And he was like, he said that we had we had made peace, and then I had lied to him, something to that effect of that I lied to him about my name and that we weren't cool anymore, basically.
Aw.
And then as we start to enter into the jail, that is whenever he said, I'm a threat for a reason. I misheard him. So I said, what? You're a what for a reason? Or you know what for a reason? And he said, I'm a threat for a reason.
Is that the only thing he said that gave you concern?
No, ma'am.
Now, I'm going to pass up in just a minute a disc and ask you if you recognize it, and give the jury an opportunity to view the video. But could you hit some of the high points of why the statements he made that were concerning to you?
So the first one that was bad was whenever the jail staff was trying to take the cuffs off of him. He was upset because I was assisting the jail staff. There was one person on his left arm and there was nobody on his right arm. And there was who I don't even know the jailer's name. I presume him to be newer, kind of inexperienced, and he was standing just directly beside us. He wasn't doing much other than he was about to unlock the cuffs. So whenever Mr. Vaughn started pulling around, I went and grabbed his right arm, so just one officer wasn't assisting. At that point in time, he's upset because I'm touching him, and more deputies come. And whenever other people get there, I step back, thinking that if I'm no longer touching him, it's going to de-escalate the situation.
Phrasing, man.
And at that time, he said, when her jaw gets broke, it's your fault. And then he continued, fighting with them. And then a female jailer said, will you stop tensing up? We're trying to take these handcuffs off. And he said, excuse my language, fuck no, I'm going to beat that bitch up. Something of that effect. Then probably one of the things that made me feel uneasy the most is after they got the cuffs off, they walked him to the jail doors for the holding area where they were putting him in. And he said, he looked at me and he said, laugh if you want to. You live in Dickson, Fairview, you talk too much, implying that I had told him too much information about myself, because I had told him that I'd previously worked for Fairview Police Department. So he was saying to me that I live in Dickson or Fairview, that I talk too much. So I told him too much information about myself.
Did he make any, did he call you by name during any of these threats?
During the actual threats, no. At one point, he did call me by name during the incident inside the jail, yes.
Was anything in his body language suggestive of who he was talking to?
Absolutely. There in several times he was speaking.
Objection, Your Honor. Speculation.
All right, restate your question.
I asked if there was anything in his body language that indicated to whom he was addressing with his threat.
Overrule the objection. She can testify about what she observed and what, that led her to believe, but that goes to the jury to determine whether or not that's reasonable interpretation for what she saw.
Officer, was there anything in his body language that indicated to who he was speaking about?
Yes, ma'am. So whenever he was speaking and he would say her, he was leaning towards my direction. One time he even looked at me, and there's another time that he's walking towards my direction and staring me down right before another officer grabbed him.
He's trying to address you with his eyes.
I'm going to pass up a disc. We will refer to this as Exhibit 1. Do you recognize what I've just handed you?
Yes, ma'am.
What is it?
It is the disc that contains my body camera footage from that night.
And have you had an opportunity to review it?
Yes, ma'am.
Is it a true and accurate reflection of the events as they happened that night?
Yes, ma'am.
Judge, I would move this in as Exhibit 1.
We'll mark it as Exhibit 1.
And then after the clerk has marked it, I would like to retrieve it. Corporal Javvens, did you, and you said that you reviewed it, you actually listened through this a couple of times, is that correct?
Yes, ma'am.
And did you take the time to prepare a transcript of what you heard on that recording?
Yes, ma'am.
Judge, at this point, when I play the body cam, actually, I'll pass up to Corporal. Is this the transcript that you prepared?
Yes, ma'am, it is.
And to the best of your knowledge, is it a true and accurate reflection of what is on this recording?
Yes, ma'am. There are pieces that I think that is documented on there that it may say like we couldn't understand what he was saying. There's some things that, especially at the end, that you couldn't hear exactly what he was saying whenever he was in the holding cell. There were only a couple comments that you could actually make out. So it doesn't have every single line, but it is pretty accurate to what's on here is what I heard on the video.
Judge, I have previously provided a copy of this to the defense. I would like to move it in as Exhibit 2 and allow the jurors to have a copy as they listen to the recording.
All right. Ladies and gentlemen, this is a transcript this witness has prepared based on her interpretation of what you're hearing, about to see and hear on this recording. It is up to you to compare that to what you hear on that to determine whether or not that is an accurate transcription.
This ends up taking a while because she can't figure out her laptop because she's a boomer. They have to take a break. They set it up.
October.
I have it.
Judge, I'll go ahead and say for the appellate record, there are 2 files on this. Yep. For the appellate record, there are 2 files on this, and I will be playing from the second file. And then I'll put my times on when the jury comes in here. All right, Judge, are you ready for me to begin playing?
We are ready.
Judge, for the record, I am beginning to play on the video screen time, so that would be the real date and time, at 22 hours, 27 minutes, and 8 seconds. And I may...
Thank you, David, for the 1999 super chat. That was very generous of you. Who is more of a ladies' man, the defendant or Salvador? I vote for the defendant because at least he has touched a woman. Thank you, David. Jesus.
Pause at points. I'll note that for the record.
Do we get out this way or on that end? Whichever one's easiest for you.
That was nice of her.
name ain't Lindsay.
That's my first name. My last name's Javvens, Javins.
So you just lying to me like all women.
My name is Lindsay.
I just gave you respect. I'm telling you.
Lindsay Javvens. Look, I try to be like first name basis with people. Lindsay's way easier to remember than
What you
Javvens.
supposed to do?
Yeah, like Lindsay's.
Same way y'all got me last time on the lawsuit. You're straight.
What do you mean?
I'm gonna meet you in person. I'm gonna let you know.
Where's your
Don't play with
name?
nobody that's peaceful. That gets
I'm not blaming nobody that's peaceful. I was being peaceful until you wouldn't get out of the car.
disrespectful as I was.
Come on, man.
I'm a threat, son.
Come on,
I'm
man.
a threat for a reason.
What?
I'm a threat for a reason.
You know what for a reason?
I am a threat.
Oh, you are a threat?
Yes, ma'am.
Okay. I didn't think that, but okay. What did I lie to you about? I'm not playing with
I
you.
don't trust women for a reason, right?
Why does it sound like she's flirting with him?
I don't trust people that don't listen to me. When they were giving them. Look, how are you gonna tell me we made peace and then start being mean
No, I'm
again?
just letting you know. I'm just letting you know who I am. It ain't no threat, not my threat.
You kind of just threatened me, but it's
Okay,
cool.
you want to, I'm sure I'm none of it. Feelings don't feel like yours, some people are fuck feelings. That's what involved the whole array, your feelings.
All right.
Actually, right.
You're shaking me really spicy. I'm having a problem over here.
This is very something offline.
What?
This is very something offline.
You still go through, you still put it in a supplement?
Who's this, sergeant in charge, man?
It's Gonzalez.
Is it the light skin dude?
Huh?
Is he light skin? Light skin, okay.
Jesus, David. The only reason I started streaming on YouTube is because I thought it would get me some of that sweet Jewish. It did not work out for me. Wonder what she's up to. Jeez.
You look like you're gonna feel like you didn't know what you were walking into.
I'm gonna put my head in the
You looked a little scared.
Never scared. I'm not sure. I'm playing again.
Nobody else. I feel like fucking hurting.
So we're just going to watch you doing paperwork. Okay. Cool. Point of view. Will she get a paper cut? Find out now.
Mr. Vaughn, you can take those off.
Don't do it.
I would just try calling back in about 30 minutes to an hour. We won't know really anything
Mr.
about
Vaughn,
it.
I gotta leave.
That's your real name. You know why? I don't talk about it.
Take the cuffs off. I need my. I'm leaving.
Yeah, you can call them. You can help them or just line and they might have some other things. But otherwise, I would just call back in about a half hour.
Oh,
All right, listen, I'm just talking about, listen, you won't be cordial, you won't be frank.
well, because that's my stuff. I need my
I
stuff.
don't trust her.
That's her cups.
Right, I will put myself in your country and we can go to this show together. She needs to be away from me. I'm asking you not to take these cups off.
Mr.
She has
Vaughn,
cooties. Get away from me,
You
woman.
walk over there. Leave, you tell her, leave me alone. I'm not gonna
however you
cause
want to do
any
it.
trouble.
I
Fuck
just
the
need this
rest.
shit so I can go.
Fuck the rest.
I need to.
Wait a minute if you want to find out.
I'm sorry.
Go ahead and get the keys. No, you're not gonna move. I'm gonna remove these cuffs off you. Stop pulling back now.
Pull it back. Why is she touching me? A female shouldn't be
Stop
touching me.
moving now!
A female shouldn't be touching me, bro. Look, I'm scared. I'm in fear for my life. She should not be touching me.
Hey,
All right.
nobody wants to hurt you.
Why is she touching me? I don't trust her. Get her off of me.
I hear you.
Please get her off of me.
Nobody wants to hurt you. Just go with the
Nobody's
flow.
going to touch you in the danger
Get her
zone.
off me. I need her touching me. Y'all can handle me. I said I wouldn't.
Nobody's touching you anymore.
Stop pulling back, Sarah!
Fucking touch me.
She's not touching you!
She fucking touch me. She's not touching me.
She's not touching you anymore.
She's not touching me. Relax.
She's not touching you.
Relax.
Her hands are off you right now.
I just told you I would keep it. I'm gonna give you no problem. She ain't got no goddamn reason to touch me. When a dog get broke, it's your fault. You don't fuck about the law.
Sorry. Hey, we're trying to get the cuffs off you. Can you stop tensing up, please?
Fuck no, because I'm gonna beat that bitch up. Get on it.
Thank
Y'all think everybody playing?
Dina for the 1999 Super Chat. Thank you so much. Today is National Fitness Day in the UK and National Comic Book Day and National Quesadilla Day in the US, in case anyone was curious. Apparently National Daughters Day too. I hope you're doing well.
You live in Dickson, Fairview, and talk somewhere. You come around, we're shaking up, meeting.
I'm sorry. He just wants to act bad since he's in here. He's perfectly fine the rest of the time. Just trying to act hard. Here's his copies right here. That's all he had. It's just whatever was on.
Just shoes.
That's all he had. Didn't have anything else.
You guys are.
Original call for domestic. He was threatening to kill his kid.
Jesus.
Judge, we have stopped play at 22 hours, 37 minutes, and 59 seconds.
All right.
Judge, I am going to keep this queued up in case during his cross-examination, the defendant wants to play any portion of this.
All right, then we'll turn the lights on.
Did this interaction at the jail happen in Dickson County?
Yes, ma'am.
Did you have you had any interaction with the defendant outside of your capacity as a law enforcement officer?
No, ma'am.
These comments taken as a whole, did you mention this to another officer?
Yes, ma'am.
And that officer encouraged you to document these?
Yes, ma'am.
Why did he encourage you to document these?
He encouraged me to document the information.
Objection, Your Honor, speculation.
Overruled.
Why did he encourage you to document these?
He encouraged me to document it in my report just in case any further action happened, as if he did try to retaliate against me, did try to assault me or anything like that. Say if I, saw him out in public somewhere.
Let's talk about assault. You did not seek charges for him on assault that night.
That's correct.
And that's because he didn't hit you that night.
Yes, ma'am.
And that is a different legal charge than the retaliation.
Yes, ma'am.
Objection, Your Honor, leading.
Sustained. Don't lead the witness.
The charges of assault and retaliation, do those have separate elements?
Yes, ma'am.
Nothing further.
Mr. Vaughn, do you have the right to cross-examine the witness? Do you wish to ask any questions?
Yes, sir, I do. Just take it off. Good afternoon. Is it Corporal Javvens?
Javvens.
Javvens, sorry about that.
Here we go.
This is the testimony you wrote, correct?
That is, yes, sir.
Here,
That
here,
is-
I wouldn't say it's a testimony, but it's what I wrote, yes.
Okay. This was because the video was, it was difficult for you to hear, correct? The reason you wrote this?
I wrote it out for myself and then I shared it with Miss Bryson, or General Bryson, sorry.
So you needed to recall it better for the jury, correct? Yes.
No, sir, I remembered what happened.
Okay. You, how long ago was this?
In 2022.
Okay, you remember what happened. Are you sure you didn't just write this out because you forgot what happened and you just wanted to,
That's one way to impeach.
so I'm sorry, excuse me. I'm brain farting here, I'm sorry.
Brain fart.
So you wrote this out so that you wouldn't forget what happened for the jury, right, correct?
I wrote it out while I was reviewing my video. I think that it's important that I did that because there were a lot of direct statements that were made that I think the accuracy is important.
Okay, so you remember it from the video or you have firsthand knowledge?
Yes, sir, from the video.
Oh, okay. So
Oh, okay.
you only remember the threat and for retaliation from the video? Or, I mean, because let me ask you this instead. So you arrested me for retaliation. No, you didn't. I was charged with retaliation, correct? Retaliation and past act.
Yes, sir, that was presented to a grand jury and it came back from the true bill.
So that wasn't the original charge, was it? That the reason I was arrested and taken to the jail, was it?
No, you were taken to jail for a different reason.
Okay.
Okay.
And you didn't charge me that night with retaliation or past act, correct?
No, sir.
Okay. Did I tell you that I was scared of women at any time during the traffic stop?
Yes, sir.
I did. Did you believe that to be true?
Not entirely, no, sir.
Oh, so you took it as joking or lying per se?
I didn't believe that you were scared of all women. No, sir.
Okay.
Trans women?
Was there another female jailer present who had her hands on me at the time when these statements were made? When they were trying to remove the cuffs?
Yes, sir. Yes, sir.
And you didn't ever hear me say your name at all or direct that towards you, that I want to do anything to you?
You looked at me and you said, Lindsay, if that's what your name is, because you were upset because you thought I lied to you. And then during that time, between the two threats of breaking my jaw and beating me up, you called me a lying ass hoe or lying ass bitch, one of the two.
Okay.
Thank you, David. Sal is more scared of women than this defendant. Thank you, David. I'm a glutton for punishment today. Hey, Jay Murray, how are you?
Your Honor, can I ask one question, please?
You may consult. Ladies and gentlemen, for further explanation, Mr. Spratt was appointed by this court as advisory counsel. He is not participating on an active basis, but he's there to give advice because of the fact that Mr. Vaughn had requested to be able to represent himself. So.
Tracy, basically, yeah, he's representing himself. Is this live? It's not. It was like from 3 hours ago. I don't believe the day's finished yet, so it's from today.
Okay, in the video we just watched, I'm sorry, your name is Miss Javvens. No, Javvens, you got to keep forgiving me for that. I'm horrible with names.
You're fine. Last name is Javvens.
Javvens, okay. The video we just watched, you said he's trying to act bad because he was in there before and he was perfectly fine the whole time. You said that, right?
At the end, I made a comment that you were acting different than you were before we got to the jail. Absolutely.
You were laughing too also, right?
Yes, sir.
Okay. So you felt no threat at the time at all that night, did you?
Threats were made to me, yes.
So you didn't feel threatened?
I did feel threatened.
But you're laughing feeling threatened?
I think that a part of my job, we are frequently faced with fear that we don't show. I've been faced with life and death situations and I didn't show
Like you
fear.
around women.
So you had no threats or interactions with me since then?
The only interaction I've had with you since then is in court.
I think this would be safe to say that I feel like these charges were a retaliation from you instead of from me due to the fact that you arrested me for illegally. Would you agree?
Mr. Vaughn, you are making a statement rather than asking a question. It has to be in the form of a question. You'll be allowed to testify if you choose to do so, but this must be in the form of a question for this witness.
Okay. Would you say that the original arrest was illegal?
No, sir.
Let me see here. I got some more questions for you.
Salvador is already
What
Googling
was
this
your
witness's
original
phone number.
charges you arrested me for?
Originally, you were charged with resisting arrest, stop, halt, frisk.
Hold on just a second, please.
Only to only
Ladies
for
and
an
gentlemen,
interview.
Step across the way, please.
Oh God. Okay, so what was his question?
With resisting.
Charges you arrested me for?
Originally, you were charged with resisting arrest, stop, halt, frisk.
Hold on just a second, please.
Opening the door.
Ladies and gentlemen, step across the way, please.
Way to go.
Walking a fine line, you've asked her a question about the original arrests. The original arrests were for driving on a revoked license, third offense, and for the second count, which the court, I think, state resisting arrest, which I think the state acknowledged. My concern is that opening the door to the evidence coming in about you're having two prior, being driving on a revoked license, third offense. And that's why I wanted to caution Corporal, I just want you, if you can answer his question about driving on a revoked license, just don't add the third offense part.
Okay.
Is that all right?
Yes, sir.
All right. Then that's the only thing. Any objection to any of that? Step back and talk to your advisory counsel.
Damn it, David. Sal wants to get that hair all tangled up in his. Yeah, okay. Thank you, David, for that. Very generous. Hard to imagine you're a lawyer.
I don't want to hinder her from
Make it simply our advisory counsel does, but there is a point where it's delaying the trial, and we're not going to continue to allow that to keep happening if it's going to be. That's fine. As I say, I'm not complaining. I'm just saying it's already almost 2:30 in the afternoon. So, what happened to our district attorney?
Defendant scared her off.
Yes, Judge.
Bring the jury in.
To my questions that I'm being charged with, and I don't want to hinder her from responding to my questions. I mean, they're going to have to know that what I'm arrested for anyways.
It's your decision as to how you ask. I'm just wanted to make clear that what you're opening the door for, and you go for it. You ask whatever questions you feel like you want. You've got counsel that's advised you, and now you're ready to go.
She is so fed up with him. Whoa. Jury's
I just
coming
was
in.
trying to take a head count. All right, I guess I could just count the empty chairs instead of the heads. All right, Mr. Vaughn, we are ready for you to continue your line of questioning.
Okay. What was the original reason you arrested me?
Resisting and driving on revoked.
Okay. Was was one of those charges dismissed?
The state elected to not proceed forward with one of them, yes.
Okay. Do you believe that I really was resisting that night?
Yes, sir.
Okay. Ron, I would like to play some video footage. if you can.
Briefly,
Sir?
if you need to consult, is that what you're saying?
No, I want to play some video
Oh,
footage.
you want to play the video?
Yes, sir.
All right. Mr. Spratt can assist you in that. So are you going to ask this witness, what is it we're watching so that the jury understand and can follow along?
It's right here, jury, is the beginning of the interaction with Miss Javvens. I can't get it right.
Right. So you're going to show the body cam footage from the initial contact between you and Corporal Javvens?
Yes, sir.
All right.
Judge, for the appellate record, this is the first file on the disk that is submitted as Exhibit 1. And we are starting at the beginning of play, and I'll note the time whenever they stop.
All right. Thank you.
All right, we're pulling into Delaware Junior now.
Oh God, I'm gonna get struck, aren't I? Smooth R&B.
You're talking real quick, man.
I'm not stepping out of the vehicle until you tell me the reason.
Well, we got a call that there's a domestic, so I just want to talk to you about
Call for a
what's going.
domestic,
Yeah.
what makes a domestic?
I got you. Somebody just called. Let me come back here and talk to her real quick. We'll talk about
I
it.
can't step out of the vehicle until I
You
commit the crime.
can't.
I reserve all my rights.
All right, well, let me tell you this. So Pennsylvania versus Mims case law says anytime I tell you to step out of the car, you step out
But I
of the
know,
car.
but you also know. that-
Case
like,
law says,
no.
no.
I'm
Case
gonna-
law says if I tell you to get out of the car, you get out of the car.
Can I have a
So
male, can
get
I
out of the
supervisor
car.
come to work?
Well, they're coming. You're gonna get out of the car when I ask you
don't feel comfortable
to.
right now because there's a female president, it's a male domestic. I've been in this
I'm
three
not.
times.
I'm just trying to talk to you.
Okay.
You're making this a thing.
No, I'm not.
Step it up for me. I don't want to talk to you. I want to talk to you separately. Okay. That's how I want to do it. That's how we do domestics. We're gonna talk to you separately. That's how we're gonna go. So I'm gonna get you to
Hold on,
step
hold on.
out of the car. So this
Am
will
I
go
under
one way.
arrest?
You're gonna step out because I'm telling you to step out
Where am
now.
I gonna stand? Am I under arrest
Step it
before I
up
step
for
out of
me.
my private vehicle?
You're not under arrest right now. I just need to
Then I
talk
have
to
no
you.
reason to step out. I'm still not under arrest.
Step out. You're gonna go to jail for resisting.
I asked
The
you-
second I put my hands on you and you don't get out of this
I
car,
asked you
you're
a
gonna
question.
go
You
for
did not answer
resisting.
it correctly. You know this.
There ain't nothing about it. I just told
I'm
you.
not under
I
arrest.
just
You
told
have no
you.
reason to touch me.
Case law says if I tell you to get out of the
It's
car,
not
you get out
about
of the car.
this. If you say I'm
It
under
is.
arrest,
Get out of the car. Come on. Get out of the car. Get out of the car. I told you to get out. Get out of the car. Get out. Get out.
Wait, hold on. Grab that before
You're
you
good.
touch me.
You're good. Ain't worried about that. Come back here and talk to me. Stop making this a thing.
Is that a male in that car?
Yes, there's two males in that car.
I want a male to touch me. Please stop touching me.
Go up here. Go up here.
I want a male to touch me.
Yeah, there's gonna be a male.
I want a
that's gonna
male
touch
to
you.
touch me. Okay.
There's gonna be a male that's
Wow,
gonna touch you.
sir.
Please touch me.
All right.
There are no females to touch me.
Dude, chill out.
So you're being disrespectful.
You've been disrespectful since
I asked you, am I under arrest? You said no. It ain't no shut up. Am I under arrest? And you said no. Then why am I
Did I
detained?
tell you to get out of the car? Did I tell you to get out of the car?
Am I under arrest? Am I under arrest?
Did I tell you? Now you are.
I reserved
Now
on
you are.
arrest.
Now you're going for resisting at minimum because I told you to get out of the car. You didn't get out of the freaking car. How many times did I tell you to get out of the car?
No, you're not.
No, he's not. No, you're not.
Right now, I think.
All right, ma'am. You step out and talk me away from the kids, please.
Yeah, we were just arguing.
I got you.
Together 15 years.
I got you. Well, there's enough that's already. Listen.
Yes, David, that is a very good point. The defendant is the one who chose to play this video because
For
he
the
thought it would help
record,
his
we
case.
have stopped at time signature 20:53:54.
Okay, are you familiar with the de-escalation process?
The de-escalation process.
Process or policy, yes.
I'm not sure what you're asking.
Do your department have a de-escalation process or policy?
We're trained on de-escalation, yes.
Okay, would you give me some idea what that looks like or from your training? What did they teach you to how to
It looks
de-escalate
kind
a
of like
situation?
that.
It varies upon circumstances and what's going on. I think that talking to people, I feel like is a de-escalation tactic of talking to people like, hey man, come out here and talk to me real quick so we can talk about what's going on. That explaining to people their legal obligation to do something and giving them prior warning of, if I have to put my hands on you, you're going to jail for resisting. I think all of those things de-escalation works two ways. Gives that person a chance to begin to comply.
Okay. You just stated that citing their legal obligation to do something, correct?
Yes, sir.
So you cited Men's versus Pennsylvania, correct?
Pennsylvania versus Mims, yes, sir.
Okay, so you're familiar with that case law, correct?
Yes, sir.
But you're not familiar with past act retaliation? That is a statute that you can charge somebody with?
What are you asking?
I believe earlier you stated that you didn't have knowledge of what the charge was, but you just took note of it in case something happened.
I took note of the threats. If you're referring to the last motion hearing that we had, when I said I was unaware that that was a thing, I was unaware that it was applicable to law enforcement. I didn't realize that we were covered under that statute. I thought that it was applicable for judges and DAs and things like that.
Yeah,
Or physicians like that, I'm sorry.
Yeah, I'm sorry. I'm just finding it funny that you're familiar with case law, but not with it.
I'm sorry.
If we could keep to questions instead of statements.
You're making statements, Mr. Vaughn. Sustain the
Okay.
objection. You
Okay.
may only ask questions.
Okay. Let me see. Did I have a seatbelt on that night?
Yes, sir.
Did I have a knife or anything else on me?
Yes, sir.
Okay. Did I give you the knife?
You told me the knife was in your pocket and I took it out and put it in the car before you got out.
Do you think that was a wise thing for me to do? To let you know I had a weapon on me?
I appreciated that.
Okay. Did that make you feel at ease? You wasn't feeling threatened any type of way?
I appreciated that you told me you had a knife on you so we could remove that from your pocket. Yes.
Okay. When you're arresting someone, is it procedure for you to tell them to shut up?
Tell people to shut up.
Yeah.
I mean, it's not typically something that I do, but in the heat of the moment, I may say things that typically aren't said.
Okay. So the heat of moment, would you mean like you were agitated maybe?
I wouldn't say I was agitated. I was I was at a different level than somebody who would have complied and got out of the car and just sorted things out when I first asked them to.
Would you please elaborate on a different level, please?
A different level as in my senses were heightened that something else might be going on, that something's wrong. I have those officer safety concerns in mind because you weren't acting like the typical person does whenever you make a stop and you say, hey, come back here and talk to me for a minute. That's typically not the response that we get.
Okay. Oh, here's one more question. I think we asked this before, but just for the record, for the jury's ears too.
For the jury's ears.
What was the original call? What was your reason for pulling me over?
The original reason was for domestic. They called in and said that you were threatening to kill the female and the children. That person was so concerned about those threats, they even came to the scene to speak with me because she was so concerned.
Okay. I'll ask you next. And that's the charge you didn't charge me with, correct?
No, sir, you were not charged for domestic.
Okay. I have some more videos I want to play, Your Honor. We can move forward.
What videos are those?
I have actually off the same video. I got different parts of it I want to play for the jury.
All right. Mr. Pratt, are you going to assist you in that?
Yes, Your Honor, I believe he's got some marked, and I'll flow with him and let you know for the record where we're at.
What?
So, Your Honor, for the record, we're starting back at 20:55 and 57 seconds. 20:55 and 57 seconds on the timestamp.
It's not besides the point when I'm in fear.
All right, man.
I'm in fear of females because in 2015, 5 females showed up to the scene.
Bro, come on now. Stop
You
that. Stop that.
You have
Stop
not
all
been where I've been.
that.
I don't know you. You're a new buddy.
Stop all
I'm not
that.
no disrespect to new buddy. I've been doing this for years.
Okay, so
No disrespect.
what happened at Walmart? Why are people
I told her to shut up. I got a phone call with people that are very dangerous telling me that my baby mama had her mouth open on their situation. I said, baby, you cannot talk. And she's still cussing me. She's doing everything. But shut up, shut up, shut up. All I repeat it.
Yeah.
I've been with her for 15 years. She still ain't gonna shut up. I don't ever put my hands on her. I don't ever do either. Look, I just brought that for her. It ain't her birthday.
I didn't say that.
He chose to play this.
I'm just gonna let you know because females make situations worse.
Oh, yeah.
That's why you heard me.
Well, he's not wrong.
It sounds like you made the situation worse by yourself whenever I told you to get out of the damn car.
But you're a female.
I tell you to get out of the car and you wouldn't get out of the car. That's the bottom line. I explained to you. I explained to you the law. I explained to you. If I tell you to get out of the car.
Listen, man, when it comes to
That's
life,
as problem as you think. Oh,
Karen's
I'm sorry.
explaining
when it comes to my life, I'm sorry, but when it comes to my life,
Okay, and that's why you go to
I've
jail.
heard that before.
Okay, and that's how you go to jail. Is if you don't follow the rules, then you go to fucking jail.
Your Honor, for the record, we've stopped at 20:57 and 21 seconds.
All right.
Okay, my next question would all right, so would you consider this an investigation still into the domestic at this point in the video?
I'd spoken to the female about the incident. I was attempting to speak to you about the incident. And if I'm not mistaken, it continues. And you said that, no, you just told her to shut up.
What I'm asking is this considered an investigation at this point in the video? This is what you're doing, correct?
Looking into the domestic, yes, sir.
Okay, all right, interrupting people while they're speaking, is that part of your training?
As a cop, yes.
Because you walked up in the video when I was talking and just start cutting
Judge,
people off.
again, questions, not statements.
The objection is to the fact that you're not asking questions, you're making statements. I sustain the objection.
Is interrupting people while they're speaking part of your training?
No.
Okay, I believe we just seen that in the video, correct?
Got her.
Interrupting you from speaking to the other officers, is that what you're speaking of?
To them, including you.
No, that's not something that they train us on.
Okay. What about profane language?
No, they don't train us on that either.
I believe you just said in the video, you're going to fucking jail, did you not?
I believe so.
Okay. What about the response? It doesn't matter what you think. Is this the proper response to people when you're investigating a domestic?
It doesn't matter what you think.
Yeah.
Six minutes, 31 seconds.
Oh, yeah, that was definitely in there.
I'm not 100% sure what that was in response to, sir.
I believe we can play the rest of that video now, Your Honor.
All right.
Your Honor, for the record, this will be from 20:58 and 20 seconds. Starting back.
All right.
So blunt splitter, what is that? Temporary.
Blunt splitter, you see how that's disrespectful?
Yeah, what is that?
Charges?
$10.
I don't want to talk to you no more.
Okay, well, you're going to jail for resisting.
Resisting? I didn't do anything.
That's how you get out of the car?
I told you I reserve my rights. I asked you the reason. That's my right.
Did I tell you to get out of the car? Did I? You don't.
Well, she'd be insufferable in an argument.
Stand
I'm
up.
scared of you. I told you I'm scared.
Stand up. Quit acting like a that's grown man. Act like a grown man. Come on, come back here. You're making this a thing.
It is. If you've been beaten, you have to look in your life.
Yeah. Let me fix
I've
this.
been where I've
What
been.
happened in the past is whatever. We're here right now.
I'm not saying to you.
What am I gonna do? Beat the shit out of you?
I'm scared of you. I keep saying I'm scared of you.
You ain't scared of me.
I am.
You ain't scared of me, man. Come on. You are not scared of me. Get in this car. Oh, child, I don't want this story. You are not scared of me. Like, not even the slightest bit.
You can't change my words. You can take them and do whatever you want. I am scared of you.
All right, get in the car.
You're a female. I'm scared.
Yeah.
Y'all make whatever y'all want to make.
Get in the car.
I'm with a white woman. I'm a black man. I'm scared of you.
That shit don't mean a damn thing to me. I don't give a shit about color. Get in the fucking car.
You don't, but I do.
Okay, get
It's
in the
my
car.
life. You ain't been where I've been.
Get in the car.
I don't give a shit about color. Get in the
All the
fucking
way
car.
in.
I'm trying.
There you go. Cool.
Hey, Nick.
Told him to get out of the car. Explained to him Pennsylvania versus Mims, everything. Told him to get out of the car. Told him to get out of the car. Told him to get out of the car. I had to open the door myself. And then I had to carry him out of the car because they want to play games.
Roger that. So she's not being.
She doesn't be cooperative. He's not being cooperative. He doesn't want my services for his domestics. So
She said at the
it wasn't
beginning,
physical.
I said, look, we got to call dude starting to kill people. She's like, he's just talking shit. He wouldn't really hurt me. And then near the end, I was like, so to be clear though, like he did threaten me. She was like, I don't remember him saying that. I'm like, okay.
Will you do my paperwork for me?
Your DV? Yeah.
I'm sure one of us, he got a wallet in here or not. He got a wallet in here?
A wallet? No.
You don't have an ID?
I'm not 100% if it's in your.
What's that right there? Is that your ID? Oh, okay.
That's my license.
I got you.
It's not a
What's his name?
His name, did he
Obnoxious.
give it to you?
No, I haven't got it from you. He's terrified of females apparently, so.
What is his name?
What's his name?
Yeah. Okay, I'll go ask
Like,
him
I don't get
myself.
why you don't need.
I was just trying to get it from you because you're like a little more cooperative than he's being, so I'm.
I'm sorry about that. Like, I'm trying to, I don't want him to go to
Is it
jail.
what's tatted on your arm?
Stupid.
Because that's kind of funny.
Well, I don't want him to go to jail.
Okay, well, he's going either way, so.
What was he going to jail for?
Can I see that real quick? I'll just use it right here.
It's gonna broke.
For resisting, 'cause I told him to get out of the car. He
His
didn't get out of the
beeping
car.
is annoying.
3 weeks when. Call him. Bring that. Like no.
Then I
He
think you also.
It's not.
They're fine. We're fine. It's not legal to argue. Everyone argues like this. It doesn't matter who you are. I'm gonna separate the people and talk to you. Okay. So that's all that was happening. That's why.
I think I went to school with you.
Finally.
Huh.
Sorry.
She got you on those videos.
No, he will, but so his name is actually Sherrick. He pronounced it Cedric. He spelled it.
Who made
like
this
he didn't
domestic
really
call?
give a fuck, right?
It's
So
better
I was
now.
trying to copy it down while he was doing it, so I was asking, but it's spelled Sherrick. S-H-E-R-R.
You got a social? Just get a social. That's the easiest way. Go ahead. 446.
Thing started out as a joke, and it's got out of control.
Did you get it? We get a social.
What's your date of birth? I can't look you up on that. That's why I'm asking.
Yeah, that works.
475.
That's your whole social?
1250. Like when I take you upstairs.
You said that's way too many numbers.
No, 470. Ask her, she knows.
I know, that's what I'm trying to figure out, man.
She gonna tell you who.
You just tatted on her arm. That's not funny, but.
What you think you shouldn't ask me, bro? Like, we have no game to play. There's no problem. She told you. I told you.
What is,
No. What, so just because that name's on her arm, though, right?
That's me.
That don't mean it's you, though.
I'm
It
telling
could
you
be
on record.
a different family member.
That is me.
Okay, I believe that. I'm just saying, when I first saw it, I'm thinking that could be a family member. I don't
All
know.
my kids and everything.
Okay, so, all right. So, what's your date of birth? We'll just do that. It's easier. You know when you were born, right?
I can tell you how old I am. Don't celebrate birthday.
2389. So you're 33. Because I'm 33. We're both 89.
Unlike Salvador, I have an actual life and a wife, so I got to jump. Y'all have fun. Thank you, David. Have a good night.
Is there some relevance to watching her pull out paperwork that we need? Stop the video.
yeah.
I understand it may be an hour or more that we're going through this. I'm just trying to determine, is there some portion of this that is relevant to the issues that the jury has to decide?
Yes, I have some questions that pertain to everything that's marked. It shouldn't be much longer.
What is? Your Honor, my list shows about 8 more minutes.
All right.
He's terrified of me, apparently.
We're intimidated.
Man's solid muscle. Not at all. He's like solid fucking muscle, man. Solid fucking muscle. Solid muscle.
That's probably.
That's different though, man. Come on.
Seriously, dude?
Yes, ma'am.
I'm the one who called.
Okay, yeah. Cool. Perfect.
He goes in absolutely screaming at her over who knows what. But then he's like, I'm gonna kill you and those kids behind you. And And he was like, I'm getting his
Where was
sister.
this at?
So
Right
I'm
in the
like,
parking lot?
yeah, on the worker side. I don't have any door. So I was like, I can hear everything. Like, he's like, I'm gonna kill you. I'm gonna get my sister to kill you. I'm gonna drag these kids. I'm gonna kill kids. Talks about hitting her. Like, I even had my boyfriend on the phone too, who can contest that he heard all of it too. He's talking about killing her and the kids, and like, so, like, I don't know how to describe it. Like pushing her kind of, like that nudge pushing her, and he was like slamming her and the doors and the door, and like just going at her. Okay. But like, and didn't you hear all that?
I do. That's what I was trying to do. You'll get that.
Well, like,
I mean, I
my
started.
My boyfriend on the
finished.
phone. He heard it all too.
I don't think she's gonna cooperate.
Yeah, but she got in the car, so it probably wasn't more than a thing. But like,
Yeah, she's not being very cooperative. Like she won't tell me much. So and neither will he. So.
yeah, but yeah.
So he was like threatening to kill the kid.
No, he was threatening to kill the kids. And like I want to tell my manager too, like what happened after I called y'all. But yeah, I saw the lights. I was like, that's probably him. So
Yeah, I did get him
him.
stopped though. I do appreciate you calling.
He was like threatening to
Do you happen to have your ID on your second log that you were my complainant? And that I had like legit reason to make contact with him, you know? Yeah.
Yeah, but he was like going at her. And like, okay.
Sweet. I appreciate you calling for real.
Like, yeah. No, other people saw in the parking lot.
As far as like putting his hands on her, you just saw like he was kind of doing that,
Oh, yeah,
like
he was
shoving,
nudging
pushing
on
her.
her. But then when they got in the car, you heard her scream, and then like they drove away fast after that. And that's when I went inside to go to my manager. If like a cop comes talking to me, like y'all know that's not me.
Yeah. Yeah, that's
So like that
brutal.
shit was he got like cruel to her.
What's phone number for you?
615-587-4057.
Cool. Yeah, the way it kind of sucks like with domestics that people don't want to like tell me what happened, and I didn't see it myself. I can't
No, but
do
yeah.
too much about it. But yeah, he's going to jail for something else.
No, but I didn't know what to do because I didn't know like in the human moment. It was like I'm right here, they're right there. He was like walking towards me and like kind of like, are you listening type thing? And I was like ignoring him on the phone with my. I was like acting like I was talking to my friend. I was like, hey, I'm going home. I'm clocking out type thing.
Yeah, I got you. Well, cool. I appreciate you coming down here and talking to her real quick. Let's get it going. Yeah. Threatening to kill her. That was down here. So that he was threatening to kill her and the kids. Like she was like all shook up. She was like, he was like doing like that nudge and pushing, and they both got in the car together. And she started screaming, and they drove off real fast. I don't really think that I have enough because she's not going to cooperate. She won't tell me any of that.
You know what that is?
It's supposed to be a cap repair. When I first pulled it out, I thought it was a blood splitter. That's what it felt like. That's what it looked like before the light was on. It was like, that's a kid.
Every time you heat up, we can't hear what you're saying, and I'm like,
Probably because he was yelling over me. Yeah, sorry. I was asking him to step it up as I was trying to do because like as soon as I walked up there, he was.
we were all the way out on West Crab Creek, almost to Lena to serve that warrant. And then I'm like, there's nobody else. So we were already coming priority, but we were so far out of it.
Yeah. I was trying to ask y'all to step it up, but because I didn't know y'all were coming hot.
Already.
Yeah, I didn't know y'all were still coming hot, but yeah. Because I knew that was about to escalate. I expected him to start acting a fool. Well, I don't think she's gonna cooperate. So. Ask him if he wants his denture stuff or whatever this is. Did you want this going with you? Or you can put it in the car?
You want that stuff?
Your repair kit thing?
We'll take your silence as a no, so yes or no. Oh, yeah, I was putting a.
Yeah, did you want this to go with you? Give it to her. Do you need anything else out of the car?
No, I want you to let me out.
Cool. There's that. He told me to just give it to you. It's like some kind of repair thing, something.
Oh,
for
it's
two. Yeah. Cool. We do all that? Cool. You haven't read it yet?
I haven't.
Okay,
No,
so,
I read it.
Look
I
me
read it.
in, yeah.
Oh, cool.
Like I went over. I did have an ex-boyfriend who did like put his hands on me.
Yeah, I got you. Look, I mean, like,
It's been years ago, but damn, I got my wrist somehow.
here's this thing.
I got it at work yesterday.
Oh, okay.
So, I don't want to get blood on me. My thing is that I got people telling me a completely different story than what I'm being told by both of you. And that's cool.
I mean, I told you, you can ask them if he threatened to kill me and then like.
Yeah, it's cool.
I can't even get back there to him.
I got you. Well, it's just so concerning
Well, I
about how
have a quick
aggressive he apparently was being with you. So, but if you don't want to cooperate,
I'm gonna be
that's-
real, like
that's
right now, I
fine.
told him, if he did, it would be a totally different call. It wouldn't be a domestic, it would probably be. I'm just not going.
All right. Well,
I can handle myself.
I got you. All right.
For the record, Your Honor, we just played continuously through to 21:13:59 seconds from the previous start time announced.
All right.
In this video you just seen, you said, stop making this a thing. What do you mean by stop making this a thing?
Yeah, you were making the situation into something that didn't need to be.
Did you say resisting, arresting me for a false resisting arrest, be making it a thing?
What are you asking?
Arresting me falsely for resisting arrest, would that be making it a thing?
I didn't falsely arrest you for resisting arrest. Probable cause was found on several occasions, actually.
Walked into that one.
Would it be making it a
Judge
thing
Ernest.
to arrest someone and not cite them when statute requires a citation?
A citation is not required for resisting arrest.
So I could have continued the resisting arrest after a citation?
Is that a question?
Yes.
What's the question?
So I would have continued, the incident would have continued if you would have cited me
Cited you for what?
for resisting arrest?
We don't cite people for resisting arrest.
Judge is so uncomfortable.
You stated to
right now.
the rest and the other officers that you called for backup, you had to drag me out of the vehicle. Did you have to drag me out of the vehicle?
Did I assist you out of the vehicle? Yes, absolutely. You can see where I'm holding pressure on your arm to get you out of the car. And you're holding up on several times and you jerked away from me at the beginning and it wasn't to take your seatbelt off.
So it wasn't to point out a knife on me or anything like that, or take the seatbelt off? That's what you're saying?
So I grabbed your arm and you pulled your arm away from me. Then you placed the cigarette in your mouth. Then you decided to take the seatbelt off. And then you started getting out. You were hesitant. I'm pulling on your arm. And that's when you were like, hold on, I have a knife in my pocket. And I took the knife out of your pocket. And then you got out of the car. We began walking back to the car. I was holding your arm and you again jerked to put your hands in the air when you were asking if those were male officers that were arriving on scene.
But the resistance came from not getting out of the car, correct? The resisting arrest charge came for not getting out of the car, correct?
Resisting arrest from the whole incident of not getting out of the car and me having to assist you out of the car, yes.
Okay. Okay, separating me to address a domestic, is that your only method of addressing a domestic? Or was that your chosen method?
It was the method that I chose that made the most sense. You're the driver of the vehicle. That keeps you from driving the vehicle away with the potential victims in the car. I don't know what's in the car, if there were weapons in the car. I have all these officer safety concerns due to your behavior and how you're responding to me and how you're acting. So the most reasonable thing would absolutely be to remove you and come talk to you instead of removing everyone else from the car because you didn't want to get out.
How many other people was in the vehicle?
Oh, you had children in the vehicle and she was in there.
Can you give me a count of how many people was in the vehicle?
I do not have a count of the number of people that were in the vehicle.
So you pulled me out the vehicle and you can't even remember how many people was in the vehicle?
Well, she was in the passenger seat and then there was a huge aquarium in the typical area where someone would be sitting as the passengers. And then the kids were in the very, very back. I'm not sure the number of kids that were in the very, very back.
You sure there was nobody else in the vehicle?
Not that I observed.
So you secured the scene for your safety by pulling me out of the vehicle, but didn't search the rest of the vehicle?
Didn't search the rest of the
I mean,
vehicle.
you didn't want to see if there was anybody else back there, maybe some potential weapons in there, weapons of mass destruction, anything in the vehicle?
I separated the parties to investigate what was going on.
Weapons of mass destruction.
I mean, you were saying for officer safety, you took me out of the vehicle, but I'm figuring officer safety is checking to see if there's any other harm in the area.
you're no longer in the car. You no longer have access to those things.
Oh, so I'm the only threat on the scene.
You were removed from the car so I could speak to you. You were the person that I was dealing with.
So I was as soon as you got to the scene, so it sounds like to me that I'm the person that you were targeting. Is this true?
Mr. Vaughn, you're making statements again.
I'm sorry, Your
You
Honor.
must- You must ask questions, not make statements.
Okay. So did you ever check the female on the scene?
Yes,
you?
sir.
You did?
Yes, sir.
You patted her down?
Oh, did I search her? You said
Yes.
checked. I thought you were asking if I checked her license. I'm sorry.
Oh, yes. Did you pat her down at any time?
I don't believe so.
Okay. You didn't feel the need to?
No, sir.
Okay. Did you check her driver's license?
Yes, sir.
Okay. What about the other witness? Did you check her driver's license?
What other witness?
The witness that pulled up at the back of your vehicle.
Judge, at this point, I'm going to object to relevance.
Sustained, that's not relevant.
The relevance being that I was also arrested for driving on revoked, Your Honor. And
how is checking the license of the person who came to the scene relevant to whether or not you were charged with driving on a revoked license?
because it seems like I'm the only person that got checked for anything at this scene, Your Honor.
Right. Well, I am sustaining the objection as to relevance. In this court's opinion, it is not relevant whether or not they checked the driver's license of the person who came to the scene.
Okay. Okay. You said there was some other people at the scene. Did you say they were victims, I believe? That where threats was made towards them. So I don't know what you call them, but there was other people at the scene, correct? That threats was made towards.
Yes, sir.
Okay. Did you have a question then?
It's my understanding they were children. Typically don't ask questions of children. It's already, traumatizing to a kid that's dealing with police in general. We've had this whole ordeal at the car of you getting out. I did not see it necessary to have this discussion with the children. I spoke to the female who was the other party who was supposed to be being threatened.
Is that procedure, not question children, or that was your own opinion?
It varies on the situation of their age. A lot of things go into play. A lot of times we do not question children.
What would you say their ages are?
I don't know their ages.
You never spoke to them at all, did you?
I didn't speak to the children. I said that.
Okay. So teenagers, do you think they're old enough to be questioned?
Judge, I'm again going to object to relevance.
Sustained, it's not relevant. You were not charged with domestic violence, and as a result of that, a lot of this information that you're going to is not relevant to the charge that's being tried. The jury is only considering the retaliation for past action charge. So you might want to focus on that. So.
Yeah, I believe I am, Your Honor. I just don't think I'm asking the questions the right way. It all stems to run together. I'm just trying to prove that I was targeted in a matter that nobody else was, Your Honor. Okay, in the video, you also said to the witness that came to the scene, you said, that's why this sucks about domestics. People don't tell me what happened, and I can't do nothing about it because I didn't see it. What do you mean by do nothing about it? What do you mean by that?
Well, the witness came to the scene and she obviously was concerned about what she observed. And I was explaining to her that sometimes victims of domestics, if those threats were made, for her to feel that uncomfortable to call police and show up to the scene, sometimes, if that all happened, sometimes the victims of domestic violence are not cooperated. They don't cooperate well whenever law enforcement come to the scene. So yes, it sucks for that victim or for that person who may need protection if they aren't cooperative with us for us to help them.
Okay. Would you believe that the witness was very credible?
Yes.
Okay. The passenger in my vehicle, would you say she was pregnant?
I don't know if she was pregnant.
Okay.
Judge, I'm going to object again to relevance to this whole line of questions.
What is the relevance, Mr.?
Just to challenge her observation of the whole scene, just to show that, once again, she was just only focused on me at the scene. She wasn't really investigating nothing, Your Honor. She had a whole objective of just wanting to charge me because I made her mad, Your Honor.
Well, I am sustaining the objection because whether or not the passenger in your vehicle was pregnant or not pregnant is not relevant to the proceeding to the issue that we're dealing with and the charge we're dealing with. Sustain the objection.
Okay. Was there a witness statement made by the witness?
No.
Okay.
Judge, I'm again going to object to relevance. The investigation of the domestic, he is not charged with domestic. He has played the video. The jury can look at it as they want. There's just no relevance to this line of
Sustain the
questions.
objection.
Okay, let's go back to the video that Ms. Danny played for us earlier. You stated that you was assisting me to place me in a cell. This be acting outside the scope of your duties?
I wasn't assisting to place you in a cell. I assisted the other officer. They were trying to remove handcuffs from you, and only one arm was being secured by the other officer. Your right arm was not secured at all. So if you take those handcuffs off, both hands are free, and now we have an arm that's not secured. I'm not going to put anybody else in a situation to put anybody else in danger.
So to put someone in danger, would you say you were the one creating the situation?
No, sir.
You have it was a body cam footage we seen, correct?
Yes, sir.
So it wouldn't show your face remarks or your smirking or anything else you're doing, correct?
No, you wouldn't be able to see my face.
Are you familiar with the jail policy for de-escalation?
I don't work for the jail.
Oh, you don't work for the jail, but you assist them at free will?
I never stopped being a law enforcement officer. I'm not going to let them be in a situation where they're placed in danger, removing handcuffs where only one arm is secured. That's unreasonable.
So when you enter into the jail and you place me in their custody, does your custody end there?
You go into their custody, yes.
So I go into their authority, correct?
You go into their custody. You are booked into the jail and you're in their custody.
Okay. So you said you're not familiar with your policy doesn't say anything about your authority ending when you place me into the jailer's custody? Your policy for de-escalation or enter into a penal facility or nothing? That it doesn't say anything about your authority ending once you place me into their authority?
I'm not sure what you're asking as far as that goes. I still feel obligated to assist if officers being placed in an unsafe situation, yes.
Okay, so let me ask you this. Does your policy state that the only time that you assist in a situation in the jail is with their requests, that you just don't jump into nothing like that?
I don't believe our policy clarifies, but if it did, I would argue that I'm not going to place other officers in unsafe situations.
But with you present at the scene, and you seem to be the problem that how are you placing officers in a situation by just stepping back and stepping away?
You were making the situation a thing by escalating the situation because you would not let them remove the handcuffs. And then they were going to remove handcuffs and we were going to have an arm that wasn't secured. That seems like an officer safety issue to me.
So I did not pull away until your hands touched me, correct?
If I recall correctly, you were walking towards me, staring me down when Officer Gonzalez or Deputy Gonzalez grabbed your arm and pulled you back.
I don't believe I was freely, I can't say that. The statement you have in your printout here that you typed, you said, on page 1, it states that, right after you told me your name was Lindsay, you said, I just gave you respect. I'm taking it back is what you said I said. You say I was joking or being serious at that moment?
I felt like at that time we were still on okay terms until we started the following statements that were made.
All right, what about when you said, what about when I stated, no, I'm just letting you know, who I am. It ain't no threat or nothing like that. You said, you kind of just threatened me, but it's cool. What did you mean by that? It's cool.
You can threaten me if you want to threaten me. Like, if that's what you want to say, you can say that. But I'm not saying that it wasn't a threat because it was still a threat.
So did you take it as a threat or did you saying it's cool because I ain't taking it as a threat?
The statement is a threat.
How did you take it?
I took it as
a threat.
You were saying I am a threat for a reason.
Did you take it as a threat? Like, was you in fear?
I think where the separation between a threat being made and an assault is the threat was made, not like an actual action happened. At that point in time, like, yes, kind of concerning that you said that, then with preceding statements added on top of that.
Let me ask you this. Was there a reason to be alarmed at that point?
I was caught off guard while you started talking about being a threat because we had been having normal, reasonable conversation before that.
Do you recall in the video where right before you went off and started to print off your paperwork, that a jailer asked me, said, "You look scared." Do you recall that? Do you think, well, let me ask you the question. Do you recall that?
The comment about you being scared?
Yeah, a jailer said that I look scared in the video.
No, one of the other deputies were talking in the background to the nurse that was there and said something to the effect of, "You look like you didn't know what you just walked into." She was speaking to the nurse that had just walked up from the jail.
No, she was actually speaking to me, but your paper, well, I can't make that. I'm trying to explain the situation, Your Honor. Your paper was actually up a little bit in the video. You couldn't see me respond, but I responded to them. Did you take that, you stated, well, you answered that statement. That was going to ask you next. Did you think that statement was serious or false? I believe those. I have for you right now would be towards the end of the video. You said, "You're laughing. You live in Dickson, Faribault. You talk too much." And you started laughing. Why were you laughing?
I'm not going to say, "Oh no, I'm so scared," because you are implying that you know where I live. I'm not going to show fear in that situation.
Did you actually charge me with retaliation of past act?
It was presented to the grand jury. I did not obtain warrants for that charge. No, sir.
What was it? How many months away was that? Like after the arrest? Would you know?
I'm not positive on the length of time.
Say about 5 months after the arrest.
I don't know the exact amount of time, but if
During that 5 months, did you receive any threats or run-ins with me or have any issues after that?
as I previously stated, I've only had contact with you during this encounter and in court.
Okay. Do you think it was necessary to put a past act retaliation on me after 5 months and no issues?
I think that it was applicable in the situation. Threats were made to me in the capacity of a law enforcement officer for doing my job.
Okay. So you don't think it was just retaliation for the false arrest?
There was no false arrest.
Okay. So you felt the charge was necessary to be placed on me?
Absolutely.
Okay. Thank you, Your Honor. Thank you.
They have any redirect?
Corporal Javvens, to be crystal clear, the person that we heard in that video making those statements to you that you identified as threats, was that the defendant, Sherrick Vaughn?
Yes, ma'am.
Could you point to him for the record, please?
Yes, ma'am. He's over here. Black shirt, red tie.
Judge, if the record would reflect that she has
The
identified.
record will reflect she has identified the defendant.
Couple of things from the video that the jury has watched. Did you let the defendant smoke a cigarette after he was already under arrest?
He continued smoking the cigarette after we walked back.
So you let him keep it, you didn't take it away from him?
No, ma'am.
And you tried to bring
He's
in
the cool
something
cop.
in a small container. What was that?
I believe it was some type of, something for his tooth. It was some type of, I think he had an issue with his tooth and it was something for that.
And you, the defendant's attitude from the beginning of the interaction, it goes up and is sort of elevated, agitated. And then we see him calm down. Does he ever get agitated
Objection,
again?
Your Honor, leading.
I don't think she's finished the question. I think she's giving a prefatory statement before she gets to the question part, but let me hear the rest of it and I'll consider your objection.
Does the defendant ever get agitated again like he is in the beginning before the interaction in the jail?
Overrule the objection. The statement she made was prefatory in nature to describe what she was going to ask.
Do we ever see him, or did you ever see him get agitated again other than what we see at the jail?
No, ma'am.
So we see moments of almost joking conversation between you and the defendant and other officers and the defendant.
Yes, ma'am. After the initial coming back, after he was in the car, the demeanor was completely different until we walked into the jail. We got to the sideboard.
I have nothing further, Judge.
Good. Thank you, officer. You may step down. They may call your next witness.
Judge, I believe there is a jury out matter before the next witness.
Ladies and gentlemen, if you'll step across the hallway, let me consider whatever this issue is, please.
This is, Your Honor, this is, for Corporal Stewart, our next witness, make motion to exclude regarding, statements, pursuant to Tennessee's rules of evidence, 403, probative value substantially outweighs the prejudice effect. And I was in custody with no ability to carry out the threats. The statements was not made specifically at Javvens, who was having victims in the indictment, who was named victim in the indictment, is not relevant to any fact about Javvens more or less true. So object to Rule 401 and 402.
You're objecting to the testimony of this of the witness who made the statements that, or repeated at a hearing earlier, that you had said you had a bullet for all of you or something on that order?
Yes, sir. I mean, he also testified that he didn't witness me state anybody's name. He just made an assumption that it was for all in law enforcement. There's no relevance to the statements.
So are you objecting to relevance, or are you objecting under the rule that exclude? I'm assuming you're looking at other, the rule of evidence having to do with other bad acts.
The Rule 401 and Rule 402, Your Honor.
All right, let me hear from the state.
Judge, I have a good faith belief that the officer's testimony will be that not only did he hear these statements, they were an hour and a half to 2 hours after the arrest and after the after Javvens would have left the jail. It shows not only a continuation of the anger directed at Javvens and other officers, but that continued anger shows that there may be an actual intent to carry it out, because once Javvens was removed from the jail and removed from his presence, he was still making threats to harm law enforcement. And they distinctly go hand in hand with the threats that he had made earlier.
The objection is made under 401 and.
Say one more rule, Your Honor, 403. And the intent was never carried out, Your Honor, stated in these rules. It's not a factor in the naming offense, or the naming charge, Your Honor.
All right. Have a seat. Yes. The objections are made under Rule 401, 403, and 404. 401 of the rules of evidence is the definition of relevant evidence. 403 is the exclusion of relevant evidence on the grounds of prejudice, confusion, or waste of time. Rule 404 is character evidence not admissible to prove conduct. There are certain exceptions, including other crimes. The court finds that the objection should be overruled because from the pretrial hearings that we had, the testimony of this witness is that he was dealing with the defendant at the jail, and that the defendant made statements that would indicate that he had intent to cause harm or made threats against other law enforcement, including possibly the corporal who testified in this case. My recollection was that he said, "I've got bullets for all of y'all." That, in my opinion, can be construed definitely as a threat, and that threat would factor into the definition of the crime for which he is on trial. So if the crime for which he is on trial constituted by threats, oral threats that are made, then those threats that are made constitute evidence of the crime itself, and therefore they are not evidence of other crimes, but rather are evidence of the crime for which he is standing trial. It is extremely relevant, and therefore the relevance, because it is the very nature of the charge for which he is on trial, the very relevance of those statements that would have been made to go prove beyond a reasonable doubt, if the jury so finds, outweighs any prejudice to the defendant. Clearly, any evidence of guilt can be prejudicial, but in this case, it is the fact that the statements that were made were part of the proof that the state intends to rely upon to prove that the defendant actually made a retaliation for past action threat. That definition that the jury has to find is that the defendant threatened to harm the alleged victim by an unlawful act, that the alleged victim had been a law enforcement and that the defendant did so in retaliation for anything the law enforcement officer did in official capacity as a law enforcement officer, and that the defendant acted intentionally, knowingly, or recklessly. So clearly, statements made at the jail after the incidents that we've seen that indicate that he has bullets, if that is the terminology for all y'all. It is extremely relevant and is, while prejudicial, it is outweighed, the prejudice is outweighed by the relevance, which goes to the very crime for which he is on trial. Therefore, the objection is noted, the record is preserved, and overrule the objection. Now, you have this corporal. How many other witnesses do you have?
Lieutenant. Only Lieutenant Stewart. No, Sergeant Stewart.
But my concern is whether or not we're going to be able to finish this trial today. I'm assuming we can move quickly through these next witnesses.
Judge, my proof with this witness should be about 10 minutes.
All right. Well, since the jury's out, let them have this as their afternoon recess, and we will come back. Let's make about 10 minutes for us. Everybody that needs to take a restroom break, and we'll come back and resume.
Stewart, is up next.
Or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God. All right, thank you. Have a seat. Speak directly into that microphone, please.
Are you Sergeant Justin Stewart with Dickson Police Department?
Yes.
Would you spell your first and last name for our court reporter?
Yes, ma'am. First name Justin. Last name Steward, D as in David.
On June 18th, 2022, were you working in your capacity as law enforcement?
Yes, ma'am.
And you were actually out on scene assisting Javvens at the original call.
Yes.
And that was the
This
first
guy
time that night
freaks
that you
me
saw
out.
the defendant.
Yes, ma'am.
Did you see him again that night?
Yes, ma'am.
Yeah, this guy
Could
is
you
freaking me
explain
out.
to the jury where you saw him and what got your attention?
Yes, ma'am. So, am I allowed to talk on the video that's been played? So, or did they see the whole thing? Or?
So let me walk you through a little bit more. So they're aware of what the call was about, but you, and let me just help you to the point that we're at. Did you go back to the jail later that night?
Yes.
Did you going back to the jail have anything to do with the defendant?
No, ma'am. In fact, what I was going to mention is that whenever she called for units to step it up, I was en route to another call for a warrant service. So once her call concluded, I then went to the call that I had told her about, and we made an arrest, and that's how I had contact with them again. So
The warrant service means someone has an outstanding warrant and you're going
Yes.
to serve it.
Yes.
Okay, so you serve that warrant, you take that person to the jail. What happens next?
So at the time, I believe I was still a corporal then. I had a recruit Floyd with me. So whenever we have recruits that are in training with us, we kind of slow down some of the paperwork as far as, where originals go, where copies go, things like that, standard training things. So once we concluded business with the subject that I arrested, who was cooperative, we served his warrant, advised his court date, et cetera. We made copies of all paperwork, and then jail staff kind of took him away. Our business was concluded. So unfortunately, at that point, that's where we turn off our body cameras, right? And Mr. Vaughn was out in the, I guess you could call it the common area on the male side and booking, and was still upset and made a comment that he had bullets for all of us or something to that effect. And I simply mentioned to Corporal, I believe at the time, Javvens, when we got back to the police department, she just needed to notate that in her report, just in case in the future, she were at Walmart or wherever, and he would actually try to follow through with those threats. So.
When someone makes a threat like that, is it common for law enforcement to note it in your paperwork?
It should be.
And you said in case she sees him out in public. What do you mean?
I mean, if she's out with her family at Walmart or the movies or anything, and he actually intended to follow through on them and cause like harm to her, and she had to defend herself, we would have documentation that she wasn't just out looking for a conflict. That threats were made, and that's obviously something we take seriously, and I believe would put any of us on edge. So,
did his remarks put you on edge?
Of course, yeah, it's always uncomfortable. That if not, I wouldn't have made it a point to go back and mention it to her that this is worth documenting. It's concerning. You're threatening, officers, and
to the best of your recollection, what were his words?
I believe that it was, I have bullets for all of you, or I have enough bullets for all of you. That's essentially what it was. So,
Nothing further, Judge. Well, actually, I'm sorry. About how much time would have elapsed between the end of Javvens' call and when you were there?
when I returned to the jail,
Yes, when you returned and you heard these statements from the defendant.
so I can guesstimate, or if I'm allowed to use my phone, I can get the exact time.
A guesstimate is fine.
Maybe hour and a half, if I had to guess, ballpark.
So at least an hour, no more than 3 hours.
That sounds reasonable.
Thank you. Nothing further.
Mr. Vaughn, do you have questions for this witness?
Yes, sir. One moment, please. How you doing?
Doing good. How are you?
Corporal Stewart.
Yes, Mr.
Oh,
Stewart.
Sergeant Stewart.
It's all right. It's all right.
Oh, you got a promotion. Good for you,
When you
buddy.
entered that jail that night, did you have your body cam on?
I would have whenever we entered with the other party that I had after the fact, if that's what you're asking about, the arrest warrant that I referenced.
Did you manually turn off your body cam?
Yes, once business is concluded with the person that we're interacting with, that's standard, yes.
And you testified previously that Corporal Javvens was not specifically mentioned in these statements, correct?
That's correct.
Okay. And you were also on scene when I was arrested, correct?
Yes.
But you're not named as a victim here today, are you?
Yes.
I believe that'll be all, Your Honor.
All right. Any redirect?
No, Judge. May he be released?
Thank you, Sergeant. You step down and you are released. You can go about your business, or you may have a seat in the courtroom. Consult with Mr. Spratt before we.
Your Honor, I believe we're going to need the jury out to take up some matters.
All right, ladies and gentlemen, I need to take up a matter quickly. There were two felony charges that weren't working. That's all. I didn't count them. So.
Per Rule 29 of Criminal Procedures, a motion for a judgment of acquittal, taking the facts into light most favorable to the state. No reasonable jury can conclude that I am guilty beyond a reasonable doubt of this charge. Your Honor, no statements were made directly to anybody. There's no harm that was done to anybody. To add insult to incident, 5 months delay, there was no carry out of these allegations of the statements I made. The intent was never there. And I believe with all the evidence that I showed to the jury, they would be acquitted, Your Honor.
All right, thank you. You wish to respond, General?
And in a light most favorable to the non-moving party, the jury has heard multiple statements that he was going to break a female's jaw, that he was going to beat a female up. All of these taken in relation and in the context of the situation means that they were directed at Officer Javvens, and the jury could easily conclude that they are in retaliation for his arrest, which was done in her official capacity.
Motion for judgment of acquittal is a procedural issue where the defendant challenges the sufficiency of the evidence. And as Mr. Vaughn himself pointed out, I have to review the evidence in the light most favorable to the state, the non-moving party, and as a result of that, I find that there is ample evidence for the jury to find that the defendant has in fact committed the crime of retaliation for past action. All of the statements that have been alluded to and been introduced by the state could be interpreted. I think it's an argument that as far as no harm, statute doesn't require harm. It requires a threat to be made against someone in law enforcement as retaliation for past action. And the argument can be made that, well, there was no present ability to carry it out and so forth, but the statute doesn't require that. So I find that there is sufficient evidence to overrule the motion. And now we move to the question of whether or not the defendant is going to put on any proof.
Maybe. I think if we have a Momon hearing ready, I think he may call a witness, but I think he's going to make a decision not to.
We're gonna, I would rather do, you talk with him and find out quickly whether or not his intentions are to testify. He should know by now, I would think.
He's not going to, Your Honor.
He's not going to, then bring him around. Let's go ahead and do the Momon hearing. He'd be placed under oath for the limited purpose of us conducting this, what's called a Momon hearing, and that is where I question you about your intentions to, I'm going to go over it with you, and then if you'll raise your right hand, let the clerk place you under oath. Then I want to make sure you do understand that you have a right to testify in this trial on your own behalf. And if you want to testify, no one can stop you from testifying. You understand that?
Yes, sir.
You also understand that you don't have to testify. No one can make you testify against your will. And if you don't choose to testify, the jury cannot draw any inferences from the fact that you did not testify. And in fact, the burden remains on the state to prove your guilt beyond a reasonable doubt as they've been instructed, regardless of whether you put on any proof or call any witnesses or testify. Do you understand all that?
I understand.
Have you talked this over with your advisory counsel, Mr. Spratt, and discussed with him the advantages and disadvantages of whether or not you want to testify?
Yes, sir, I have.
And do you believe it's in your best interest to testify or not to testify?
I believe it's in my best interest not to testify.
All right. And upon your decision not to testify, I'm going to ask you to sign this form. Mr. Spratt, I realize that you are advisory counsel, but I'm going to ask you to sign as advisory. All right, thank you.
Sorry, David.
I will.
See that come up. CR later.
Yeah. Are you going to call any witnesses? All right, then we're ready for the jury. Ladies and gentlemen, the state has rested their proof. Mr. Vaughn, do you have a witness that you wish to call? All right, call your witness.
I'll call Jennifer Dozier.
Oh, he's not even going to give his opening. He forgot. Also, he's going to call the woman in the car.
You'll come around, please, ma'am, and raise your right hand and let the clerk place you under oath.
Yes, sir. Do you solemnly swear?
Mr. Vaughn, you may question your witness.
Nice shirt, ma'am. I appreciate you dressing up for court.
1 second, Your Honor.
Oh, good Lord. Take your time. We're hourly.
Jennifer Nicole Dozier.
State your name for the record, please.
Jennifer Nicole Dozier.
How do you know me?
20 years and 3 kids.
Okay.
Pull that
So,
microphone towards you a little bit, please. There you go.
And we have 3 kids together.
Aw.
are you familiar with this case here today?
Yes.
The initial call that the police were called for, are you familiar with that?
So we were arguing.
Yes. What did they say it was when I got to the scene?
We were arguing in Walmart.
Okay.
As one does.
Are you familiar with the statements that were made, the reason they came?
I don't remember. It's been years.
Well, the statements that were made were statements that I could cause harm to someone in the vehicles or to yourself. Do you believe that it was possible that I could cause harm to you?
No, not in that moment. We were arguing over a birthday cake.
Do you think I'm someone that should people be scared of?
No.
Would you think I'd be the type of person to retaliate on somebody or dwell on things?
Not to my knowledge. Not that I've seen you do in 20 years, but.
One of the charges that I was arrested for was resisting arrest. I don't think that's a good question, but I'm gonna ask it. Do you believe I should have been charged with resisting arrest?
Well, no, but The charge was dropped, correct?
Yes, it was.
So
Do you believe I should have been charged with that? Do you feel like I resisted in any way?
no,
From your own knowledge, there was other people in the car, correct?
children.
Are they well capable of speaking English and understanding English?
Yes.
Do you think that if they were in fear that they would have spoken up if asked?
Yes.
You being their mother, do you believe my kids are in fear of me?
I mean, you're their father. They're supposed to be in fear of you at times, but
Okay. Do you think that they would think I would harm them?
no.
Do you believe that the arresting female officer on the scene, do you believe that she addressed the issues to the best of her authority, you think?
I think she did.
You think she
I mean, I
did?
think maybe she could have called a male officer, but they could have been shorthanded that night. We don't know what was going on.
Okay. I think that'd be all, Your Honor.
All right. State, have any questions?
Judge, I'm going to need a jury out before we have questions.
Ladies and gentlemen, if you'll step out across the way, I will need to take up a matter in your absence. General, you may ask, or you may make your argument.
Judge, I am giving the court notice that I am about to go into prior bad act evidence by the defendant, asking this witness if he is capable of harm. He has opened the door to prior bad acts, including that he has previously been convicted of aggravated assault, aggravated robbery, a second aggravated assault, and a second aggravated robbery, if this witness knows that.
Yes, I am aware of that. I don't feel like
You just
he's,
need to be quiet. I'm taking up lawyers are making a motion, so I'll have to be the one to deal with that. Door has been opened, not just open, but flung wide open.
Wide open.
And scotched open, it seems to me, by Mr. Vaughn when he asked the question about whether or not he would be the kind of person who would commit that type of an offense. So.
Great going.
Is advisory counsel.
I think it was State versus Wood that voting about that. Advisory counsel can be standby counsel. Could be a situation where this could be a situation where
The rule, the court rule is he elected to represent himself. And with that, as I asked him, if he had familiarized himself with the rules of evidence and so forth, then it becomes imperative on his behalf to make sure he's familiar with. And of course, he's quoted in the pleadings he filed that we had motions on, numerous case law, or numerous cases, a lot of case law, a lot of rules. He's cited rules today. There's a line at which he's responsible for whatever he chooses to do. And he was advised he would be held to the same standard as a lawyer. Clearly, a lawyer who asked the questions that he asked about his client opened the door to the question of whether or not. Right now, the jury has heard this witness say, oh no, she doesn't think he's the kind of person who could do that kind of threat. That's a very material issue in the case having to do with a threat of retaliation for past action. The very gravamen of
Big
which
time
is that he
kicked
is
open.
capable of making that argument. So the state has the right to now produce evidence to show that this defendant, through this witness, is capable of such actions if he has in fact been convicted of other crimes. My intention is to allow this evidence to come in and to give the jury a limiting instruction. Their instruction will be that they are to consider this evidence only as it goes to the credibility of this witness's testimony regarding her belief that he is not capable of such. He does not pose a threat and is not capable of that type of action.
I understand the court.
No, we're moving forward. The reason is, it's not going to make any difference whether you have 5 minutes. You can sit there and have 5 minutes with him, but the fact of the matter is that we're moving forward with the questioning of this witness, and Mr. Vaughn you can consult with him, but it's not going to change my ruling. All right, General Bryson, question the witness as to what the question, ask the questions you're going to ask in front of this, in front of the jury of this witness.
Judge, while this will not be the full cross-examination, the pertinent questions will be, Ms. Dozier, are you familiar that the defendant was convicted of aggravated assault in November of 2016?
Yes.
Are you familiar that he was?
Objection, Your Honor. Basis knowledge.
We're having a hearing, Mr. Vaughn, and for me
There's
to
no
determine,
jury.
the jury's not here. We're having a hearing for me to determine whether or not this evidence should or should not come in. So you just sit quietly. I'll give you a chance to question, to make your argument, or through your counsel. I'll let you make the argument. Go ahead.
Are you aware that he was also convicted of 2 counts of aggravated robbery in 2016?
I am.
Are you aware that he was convicted of aggravated assault in 2011?
I am.
Those are the questions, Your Honor.
So you're asking her about convictions of the defendant for aggravated assault, aggravated robbery?
Yes, Judge, he has 2 convictions for each that are listed on his range notice and impeachment notice.
All right. Then your argument is on the admission of this evidence is what?
Judge, under Rule 404A, the character of the accused on a pertinent character trait offered by the accused may be rebutted by the prosecution. And Judge, the defense having put forward that he is not capable of harm, these are crimes of violence which would directly rebut the evidence that he's put at issue.
All right. Mr. Vaughn, you wish to address that?
The little walk there of shame.
Your Honor, the
Oh,
questions that I were asking were pertaining to retaliation. And to the best of my knowledge, I believe she doesn't know nothing about the convictions of the defendants. I can ask her yourself for the record, Your Honor, if you want me to. Ms. Dozier,
No, we're not asking her any more questions.
Okay.
Now we're talking about the fact of whether or not this evidence should or should not be admitted. I'm giving you a chance to tell me why it shouldn't be admitted.
because the questions I was asking was pertaining to harm to the children, and Pertaining to retaliation of past acts, she doesn't have any knowledge of my convictions.
You ask her the question.
So
You ask her the question.
You asked
I'm
her if
asking
you
her
were
questions from the
violent.
time that me and her was together at these charges, Your Honor. She doesn't have no true knowledge of them charges. Me and her wasn't even together when them charges happened, Your Honor.
Well, that may
that's
be,
why
but
she
she just
has to
testified on
ask.
direct with General Bryson that she was aware of all of those convictions.
She wasn't given a copy of none of that.
He is correct. They were about his kids. And if he could argue that efficiently.
Yeah, I don't believe it should be used, Your Honor.
All right, thank you. Court is going to allow the state to ask the questions, and I will simply limit your question to, is she aware of the fact that he's been convicted of aggravated assault and aggravated robbery in the past, without going into the multiple counts of aggravated assault? I don't think there's any reason for doing that. I think you can establish what you're trying to establish by simply referring to his prior conviction, if she's aware of the fact that he has a prior conviction for that. I still intend to instruct the jury that I'm allowing this information over the objection of the defense for the sole purpose of testing the credibility of this witness and her testimony as to in response to the questions the defendant himself had asked about whether or not she thought he was capable of these things. Bring the jury in.
Do big women like black men as much as black men like me big ladies? David, thank you for the super chat. I appreciate your support of the channel and continued embarrassment of me. Yeah, don't ever ask somebody if you're a good person when you're testifying or when you're cross-examining or on direct.
That was made, offered the test to some testimony that was going to be offered. The state is about to ask some questions of this witness. I am allowing the state to ask questions that because of the fact that the defendant asked this witness questions about her belief as to whether or not he was capable. You'll remember what was the questions were, whether or not he was the kind of person that would have posed a threat and so forth. So the state is now seeking to rebut that testimony by offering questions of this witness regarding some other matters. I'm allowing it to be introduced solely for the purpose of testing the credibility of this witness on the issue on her testimony in response to the defendant's question. You should not consider the evidence you're about to hear on the issue of guilt or innocence per se, but only on the issue of the credibility of her testimony about whether or not he poses a threat or he posed a threat and so forth. So the state may now cross-examine the witness.
Ms. Dozier, you testified that you and the defendant have been together for 20 years?
On and off.
On and off. And you have 3 children together. What are their ages?
17, 15, and 12.
And you testified that the defendant was not capable of harm. Just yes or no?
I did.
Okay. And you are aware that the defendant has previously been convicted of both aggravated assault.
Objection, Your Honor. Basis of knowledge, ask the witness to lay a foundation. Basis of knowledge, Your Honor.
Overruled.
You are aware that the defendant has been previously convicted of both aggravated assault and aggravated robbery.
I was where he's arrested on. I didn't attend his court proceedings, but I knew he went to jail, of course, or prison. Excuse me.
Nothing further, Judge.
Redirect of this witness.
Good luck rehabilitating.
To the best of your knowledge, have I ever retaliated to anybody in these charges?
Not to my knowledge, no.
To the best of your knowledge, was any of them hurting any kids?
No.
Okay, thank you.
Thank you, ma'am. You may step down. You may have a seat in the courtroom or you may leave. Mr.
Yeah,
Vaughn,
she
you may
even said
call your next
prison,
witness.
which means convicted. unless you're Richard Allen.
Defense rest, Your Honor.
All right. State have any rebuttal proof?
No, Judge.
All right, ladies and gentlemen, you've heard all of the evidence that you are going to receive to be able to decide this case. The next step is for the lawyers or the state and Mr. Vaughn to make their closing argument. I would remind you that the closing arguments, both of the state and of Mr. Vaughn, are not evidence. They are not testimonial. They are not evidence. They are simply their argument to go first, and they have the right to go first and also to close after the defense.
All right, prosecutors coming up.
Ladies and gentlemen, put before you today is to decide a very narrow set of facts, whether or not the defendant on June the 18th in 2022 knowingly threatened to harm Officer Lindsay Javvens by any unlawful act in retaliation for anything Officer Lindsay Javvens did in an official capacity. On that night, Officer Javvens arrested the defendant and took him to the jail. When they got to the jail and you were able to listen to the video and you have the transcript from Officer Javvens, it's up to you to decide what you think was said on that video. The transcript is an aid to help you. But the state would submit the following statements demonstrate very clearly that the defendant knowingly threatened Officer Javvens for her arrest of him that night. I am a threat. I am a threat for a reason. Officer Javvens will say, you kind of just threatened me, but it's cool. And the defendant says, you can take it anyhow you want to. I don't care about none of that. When they begin to take the cuffs off him, notice what he said. Don't take them off right now. Don't do it. He says, Lindsay, if that's your real name, you done lied to me. I done told you I don't trust women for a reason. Stop talking to me. As they begin to get the cuffs off of him, he says, when her jaw gets broke, it's your fault. Okay? He then screams, lion ass hoe. Okay, he's accused only one person of lying. That is the officer. That tells you who he is directing this tirade at. It's directed at her because he's decided that she's lied to him.
And she's a hoe.
He then says, and ladies and gentlemen, I'm going to use his words because those are his words that you saw in the video. The female says to him after he says lion ass hoe, the other female in the room says, hey, we are trying to get the cuffs off of you so you can stop tensing up, please. And Vaughn responds, fuck no, because I'm going to beat that bitch up. Bet on that. As he's going into the cell, he turns to this officer and tells you about something she already told you in their earlier conversation. He says, you laughing? You live in Dickson, Fairview, you talk too much. And then he continues on once he's placed in the cell. Ain't none of y'all safe without a goddamn badge. And then an hour and a half, 2 hours later, he is still speaking in the vein of these threats he's already made. As he says, where Corporal Stewart hears it, he's got enough bullets for all of you. Law enforcement should be able to do their job based on the facts and law in front of them and with no fear of retaliation for what they've done. That is why threats are enough. The officers told you they documented these because these statements might become relevant later on. That tells you the mental effect that these threats had on law enforcement. That tells you that they perceived them as serious, that they perceived the defendant could act on them. And under the law, it is the threat alone that is enough for punishment. Is everyone here very thankful that these threats were not acted on during that time span? Yes. But this isn't an assault charge. He doesn't have to have hit her in that moment. This is a charge for retaliation for past action, and it goes to the threat that were a direct response to her action as law enforcement.
Vaughn?
With all the evidence that is shown here today, can we say that we're happy about what happened? No. Can we say that we believe that we should be charged with something like that? No. If the charge should be, I should be charged with something like that, I believe it should be immediate. I made bond probably 12 hours afterwards on the street, went and opened up a business. Actually had a first responders meal for $8 on a food truck.
I had a
I build
meal.
houses too in the community.
Judge, I'm sorry, the defendant has opted not to testify and
Well,
stuck.
You can make an argument about what the testimony has been in this case and the interpretation of that testimony, but you cannot testify, which is what you're doing now. I sustain the objection. Jury will disregard.
Okay. Be honest, like, who hasn't cussed a police officer out before? You get pulled over for a ticket, whatever. I don't care what it is. They get on your nerves just like they get on my nerves. I'm an American. Did I do?
Okay, one, I need that clip. Two, that is the greatest argument I have ever heard in closing. This is America.
Do something? No. Did I speak in writing? That's debatable. There was.
Sustain the objection. Jury will disregard.
Okay. Be honest, like, who hasn't cussed a police officer out before? You get pulled over for a ticket, whatever. I don't care what it is. They get on your nerves just like they get on my nerves. I'm an American. Did I do something? No. Did I speak in writing? That's debatable. It wasn't even direct. Throwing stuff out in the air. Should you be? Everybody in here probably said something. Every one of y'all should be charged with it, if you ask me. With the evidence provided you, I've also shown that if it wasn't for the fact I was even arrested in the first place for a charge that they chose to dismiss, a charge that y'all didn't even hear today, this charge wouldn't even been put on me in the first place. I've also took the charge of driving on revoked, which I had very good arguments for that. Documents I could have put in today, but just to show y'all that I was being honest about the situation, just to gain some value with y'all, to be honest with you. Just shorten this time with y'all being here so y'all can get back to y'all families. So looking at all the facts that were stated, the officer, there was no fear. This was just retaliation because she couldn't get me for nothing else. It's just simple as that. She's laughing, antagonizing. Really, you ask me, just going outside of her way, if you ask me personally. I'm hoping y'all see it in the same light I was seeing it in. You've heard the statement from my children's mother. She was present. The children were present. None of them feel any harm. They wanted to go home with me. You heard that in the video. I think this was blown way out of proportion. If I was a threat, I had plenty of time to do it. If it was that big of a deal, besides taking a note of it, why wasn't I arrested and charged with it then? Bottom line. It shouldn't be something to be dragged out. If you want justice, do justice then. It's simple as that. I believe I got, that's all I got for y'all. Thank y'all.
Colonel Bryson, do you have any final say?
She doesn't know what the hell to do with that.
No, Judge, I'll stand on my argument.
All right. Then let me have one of you pass this out to.
No rebuttal. I mean, the charge is kind of chicken shit a little bit. This one, I think this other stuff is genuine. But he technically did threaten her.
Along with me. The defendant, Sherrick Vaughn, is charged in the indictment with the crime of retaliation for past action. The defendant pleads not guilty to the indictment and to the offense contained therein. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of respect to circumstance punishment.
It's almost over. Come on.
May retire to begin your deliberations, and the court will stand at recess pending the return of the honorable juries.
Okay, well, they were out for 20 minutes before.
I'm going to sit here and sign some documents, so I'm not getting up. Everybody back. Let me get my court reporter in place. Jury to come in. So
do we have a verdict already today? I wasn't expecting a verdict today.
All right. Everybody present, we're ready for the jury. I'm told the jury has reached a verdict, so we are ready for the jury to come in. So bring the jury in.
Hey, Fletcher. 18-minute verdict. Okay. Yeah, they're back. 18 minutes deliberation. Oof.
All right, ladies and gentlemen, I'm advised that you have reached a verdict. Is that correct? Would the foreman or the forelady please stand and let me ask this as to the charge in the indictment for the charge of retaliation for past action. How does the jury find the defendant, guilty or not guilty? All right. If this is the unanimous verdict of all of you, would you so signify by raising your hand? All right, let the record reflect that it's been a unanimous finding that the defendant is guilty of retaliation for past action. Ladies and gentlemen, thank you for your assistance in this regard. This was apparently my only trial that I'll have this term. October the 1st is a different judge, right? Judge Bateman, okay. You have a different judge who will be here for the October 1st date. So check that number. I'd like to be able to tell you that you don't have to serve again. But unfortunately, we can't guarantee that just serving on one jury will exempt you. Once you're done with this term of court, you are exempt for 2 years, but you're still going to be on the hook, so to speak, until we finish with the term of court. All right, so ladies and gentlemen, you may leave if you'd like to exit through the doorway, and then the bailiffs will show you out. Let's have them exit through this way. They'll show you how to exit the courthouse. If you'll turn your badge in to the bailiffs as well. Any items that you have in the jury room, please grab those. All right.
He threatened a
Verdict was
law
guilty,
enforcement
so
officer.
we need to order a pre-sentence report. My suggestion is, General, that we set Mr. Vaughn's case on Monday, the 29th, for us to not only set the pre-sentence report or the sentencing hearing, but also to assign a trial date for his next
Monday.
case that is going to be tried, and I assume that would be one of the 3 cases he has remaining.
3.
Do you want to give that some thought, and we'll go from there? Mr. Vaughn, I want you to consider this at this point. As I explained to you, you elected to represent yourself in this case, and I think you've had kind of a taste on what that is like. The next trial, I believe there's a much more serious charges of aggravated kidnapping and aggravated assault and so forth, if I remember correctly. And I want you to consider between now and Monday whether or not you would want to have appointed counsel, actual counsel representing you, or whether you continue to represent yourself. If you continue to represent yourself, then I will not likely, unless there's some showing of a reason to appoint an advisory or elbow counsel for the remaining cases. So we will bring you back on Monday, and we'll set trial dates on those new cases and set a sentencing hearing. We stand adjourned until that time. So.
Okay, that's it. All right. I will keep an eye on this. So Monday he'll be back, the 29th. Hopefully we'll be able to see the rest of his trials. I don't know if an attorney would have presented the closing argument the way he did. Well, telling the jury we've all cussed out cops before. It was a bold strategy, Cotton. I think the charge was kind of pointless, kind of a waste of time, considering all the other crap he's getting. The officer didn't really seem all that threatened by it. She just kind of made a report because she needed to in case something happens in the future. Yeah, but I don't know. It seemed very nitpicky. Should have taken the stand. Have you not cussed out a cop? No, I have not cussed out a cop. My dad has. But my dad cusses out everyone. Yeah, Brigade has cussed out many cops. Yes, I know, Helly. You flirt with cops, it works better. So yeah, this was fun. I guess we're not coming back tomorrow because we finished it today. So everybody, thank you for being here. I will try and get another trial going for next week. Hi, Hella. Always wanting you to come on earlier. I think you slept in and had to get your beauty sleep. Sal, kiss your... What the... Why? And we need daily extra cases. I know, right? I'm keeping an eye out, seeing what I can find. But I'm going to end now. Sean's going in a couple hours. Potentially criminal. So that should be fun. And I will see you guys back tomorrow at 10 Eastern for Courtroom Roulette. Thank you, David, for all the super chats. That was very generous of you. Borderline harassment, but I appreciate it. Bye, guys.